Magandang araw. This is our video discussion of module number 14 for BAM242. Our lesson title is Intellectual Property Law Part 1, Patents. And these are our lesson objectives. At the end of this module, I can understand the general provisions, patentability, and right to patent. Number 2, explain the process of application and cancellation of patent. Number 3, state the rights of patentees and explain the infringement of patents. And number 4, understand voluntary and compulsory licensing, assignment, and transmission of rights. So do not forget that in this particular module, we are going to discuss patents. This is our productivity tip for today. We should all be like the players in the professional basketball championship series. They are determined to finish the game strong no matter what. They prepare, they plan, and strategize to deliver the greatest games of their lives. Regardless of what happened the last game, they still show up for the next game with the same intensity as if it was the first time. Happy learning. This is our lesson preview. You should know for a fact that the Intellectual Property Code of the Philippines took effect on January 1, 1998, and it is the Republic Act number 8293. Again, Republic Act number 8293, otherwise known as the Intellectual Property Code of the Philippines. In this particular preview, it shows you how important it is for us to have a law like the Intellectual Property Code of the Philippines. Bakit nga ba importante na meron tayong batas na tulad nito? Bakit nga ba ang Estado ay gumawa ng ganitong batas? Kasi ang sabi rito, the state recognizes that an effective intellectual and industrial property system is vital, kinakailangan to the development of domestic and creative activity. It facilitates transfer of technology. It also attracts foreign investment and ensures market access for our products. Of course, it also protects and secures the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creation. Why is it important for us to protect and secure the exclusive rights of these people? Kasi alam nyo, yung mga imbensyon na pagkakakitaan din nila yan. Kung basta-basta ito magagaya ng kahit sino man, syempre, kawawa din naman yung ating mga inventor. At saka madi-discourage din yung iba pang may potensyal na mag-create ng mga magagandang bagay na gumawa. Kasi madi-discourage sila sapagkat alam nila na hindi naman sila pinoprotektahan ng batas. That is why there is this law, Intellectual Property Code of the Philippines. Okay. So, let's move on. It says here that the use of intellectual property also bears a social function because to this end, the state shall promote the diffusion of knowledge and information for the promotion of national development and progress and the common good. Alam nyo kasi kapag na-encourage natin ang mga bright minds at mga gifted people na mag-create ng iba't ibang mga invention na makakapagpagaan ng buhay ng tao dahil alam nilang ito ay pinoprotektahan natin, hindi ba maganda rin ito para sa ating bansa as a whole? That's why this Intellectual Property Code of the Philippines is a very good law because it is not only a law that protects them, but it's also a law that encourages other potential inventors, scientists, and artists and other gifted citizens to come up with something new to make lives better. Okay, so you need to know that intellectual property rights that have been defined under Section 4 is consist of the following. Of course, copyright and related rights pertaining to books, trademarks and service marks, geographic indication, industrial design, patents, ito nga yung pag-aaralan natin ngayon, and then we have layout design or topographies of integrated circuits, and protection of undisclosed information. So in this particular module, be ready to learn the pertinent provision of patents. Why is it important for BSA students like you to know everything about, to know the pertinent provisions on patents? Well, it's very important now, not only because it is part of your sabihin natin RFBT examination for the board exams, but also it's very important for us to understand the law on patents because it also is monetized. Monetize din yan. May monetary value din kasi na pwedeng pag-usapan na makukompute dito. Kaya naman importante na naiintindihan natin ito. Okay. Ayan. So you need to pause this for a while and answer the what I know chart. Pag-usapan natin yung patent. So gaya nga ng sabi ko, it's very important for us to recognize patent or to know things about patent. Why? Because it is something that we put value and we recognize this as an asset. So as PSA or as accountants, we should have a fair knowledge of this particular topic. So what is patent? A patent is a monopoly granted only for a specific purpose and objective. So a patent is a form of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention for a limited period of years. So, in exchange for publishing and enabling public disclosure of the invention. Patent has the following purposes. Of course, number one, to foster and reward invention. It promotes disclosure of invention to stimulate further innovation and to permit the public to practice the invention once the patent expires. And then the stringent requirements for patent protection seek to ensure that ideas in the public domain remain there for the free use of the public. So, by now, alam niyo na kung ano ibig sabihin ng patent. Alam ko naman na familiar kayo sa salitang patent, di ba? Para bang ito yung pinapa-exclusive mo lang, pinaparehistro mo lang under sa iyong pangalan, yung ina-invento mong isang bagay. So, bakit mo yun kailangan gawin? Para nang sa ganon, may exclude mo yung iba para gamitin o kaya gumawa rin ng ganon o magbenta ng invention na ganun sa'yo. Kaya nga lang, there is a limited period of years para dito. So pag-usapan natin patentability, lahat pa pwedeng ipapatent. Porkit naka-invento ko ba ng isang bagay, ibig sabihin pwede mo na ba siya agad ipapatent? So pag-usapan natin yung patentability. So ano nga ba ang mga patentable inventions? So sabi dito, any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable shall be patentable. So it may be or may relate to a product or process or an improvement of any of the foregoing. Okay, so a patentable invention may be or may relate to the following. Please know na you need to really read the Republic Act ano ba 'yon? 8293, sorry. Kalimutan ko. Hindi ako mamali. Ayun, tama, 8293. So you need to read it in whole. Yung Republic Act 8293. Tsaka huwag niyo kalimutan may implementing rules and regulations yan. But of course, in this particular module, we are touching the most vital, pertinent provisions of this law. So ano nga ba ang mga patentable invention? A product such as a machine, a device, an article of manufacture, a composition of matter, and even a microorganism. What else? A process such as a method of use, a method of manufacturing, a non-biological process, a microbiological process. And then C, mga computer-related inventions. Pwede rin naman yung improvement of any of the foregoing. Yung improvement ng mga nabanggit. Ayan, pwede rin yung mga yon. Okay, so ano naman yung mga hindi pwedeng i-patent na mga invention? The following shall be excluded from patent protection, yung mga discoveries, scientific theories, and mathematical methods. Hindi yan napapatent. Ano pa? In case of drugs and medicines, the mere discovery of a new form or new property of a known substance which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use for a known substance, or the mere use of a known process unless such known process results in a new product that employs at least one new reactant. So, here, makikita nyo dito na kapag yung medicine ay bago pa lang, yan, pwede mo yung ipapatent. However, kapag yung medicine o yung drugs na discover mo is just a new form of an old medicine that is already known to the people or to the market, then unless yun ay makaka-improve ng efficacy, hindi siya magiging patentable. Ganon din naman kapag nakadiscover ka ng mga new property ng isang substance, no? Okay, hindi siya patentable. And of course, yung isa ng ba, meron ng isang process na known na, alam na ng public, tapos nakaisip ka lang ng bagong paraan kung paano yun gamitin, then it's not patentable invention. Ano pa? So, schemes. Schemes, rules, and methods of performing mental acts, playing games, or doing business and program for computers. That's not patentable. It's not patentable yung methods for treatment of human or animal body by surgery or therapy and diagnostic method practice on the human or animal body. Because this provision shall not apply to products and composition for use in any of these methods. Yung mga plant varieties, mga animal breeds, ayan. Yung mga aesthetic creations, and anything which is contrary to public order or morality. These are not all patentable. Pag-usapan natin yung right to patent. Kung nag-uusap na dalawa, tignan natin kung pinag-uusapan nila. The right to the patent belongs to me because I was the first one to invent it. You may be the first one to invent it, but I have more right than you do because I was the first one to file an application for such invention. So kaya yung tama dito sa dalawa, yung unang naka-invento, yung unang nagparehistro. Let's see. Right to patent. The right to patent belongs to the inventor, his heirs, and assigns. Now, when two or more persons have jointly made an invention, the right to patent shall belong to them jointly. So, syempre, dalawa silang naka-invento, dalawa silang may karapatan sa patent. If two or more persons have made the invention separately and independently of each other, the right to the patent shall belong to the person who filed an application for such invention. Okay, so you see? Dito sa dalawa, sinong mas may karapatan? Yung unang nag-file ng application. Okay. So moving on, dito tayo. Where two or more applications are filed for the same invention, okay, the right belongs to the applicant who has the earliest filing date or the earliest priority date. First to file rule. Halimbawa, pareho naman sila nag-file. Sino yung unang nag-file? Okay. So the person who commissioned the work shall own the patent unless otherwise provided in this contract. So halimbawa ako, gusto kong maka-invento ng something, tapos kinumission ko kayong lahat para tulungan ako, kanino yung patent? Sa akin. Okay? So in case the employee made the invention in the course of his employment contract, the patent shall belong to the employee if the inventive activity is not a part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. So kung halimbawa ako naman yung employee ko kayo lahat, ang gusto ko naman talaga madiskubre ay kung paano gumawa ng cellphone na lumilipad kasi tinatamad ako halimbawa na kuhanin kapag nakalapag dun sa malayo. So gusto ko pag tinawag ko siya, lalapit siya sa akin. So ginawa ko kayong empleyado kayo lahat. Pinuha ko kayong empleyado lahat para tulungan ako na gawin yon para ipapapatent ko. If that's the case, kapag natulungan nyo ako na lumipad yung cellphone papunta sa akin, then the patent belongs to me. However, if even though you are my employee and you are using the facilities, etc., then accidentally you have discovered something else which is not related to the one that I'm trying to ask you to do for me, then the patent belongs to you. Halimbawa, in the course of the journey, na paggawa ng cellphone na may pakpak, nakadiscover ka naman ng ballpen na lumilipad. Okay. Ballpen na lumilipad, diba? Tinatamad ka, laging yung ballpen na iiwan mo. So, ang ginawa mo, lagyan mo ng pakpak yung ballpen, tapos tinatawag mo lang siya, tapos lumalapit sa'yo yung ballpen. Hindi naman yun yung pinapagawa ko talaga sa'yo, diba? So, kumbaga, accidentally, nagawa mo lang siya. So, the patent, if you file patent for it, then the patent shall belong to you even though you are an employee and you're using all the facilities. Ayan. Okay, so moving on, the employer, if the invention is the result of the performance of his regular assigned duties, unless there is an agreement expressed or implied to the contrary. So, yun nga yung pinag-usapan natin. So, who may apply for a patent? Can anyone apply for a patent? Sabi rito, any person, natural or juridical, may apply for a patent. So, if the applicant is not the inventor, the official require him to submit a proof of his authority to apply for the patent. So, corporation pwede, natural na tao pwede. So, unity of invention. So again, unity of invention, the application shall relate to one invention only or to a group of invention forming a single general inventive concept. So if several independent inventions which do not form a single general inventive concept are claimed in one application, the director may require that the application be restricted to a single invention. So ano ba yung unity of invention? Okay. So, meron kasing isa na general, sabihin natin na single general inventive concept. Single general inventive concept na minsan it is composed of several new inventions. So, parang imaginein mo na yung mga bagong invention pinagsama-sama para makabuo ng isang single general inventive concept. So, yun yung tinatawag natin na unity of invention. Ngayon, kapag yung mga iba't ibang invention, pag pinagsama-sama mo, hindi naman nakakabuo ng single general inventive concept, then the office shall require it to be registered independently from each other. Pero kapag ito ay nakakabuo ng isang single general inventive concept, then yung invention na yon ay i-rehistro as a single general inventive concept even though it is composed of several other inventions. So sana naintindihan nyo itong unity of invention. Okay. So ito na yung mga dates to remember. So, a later application filed for an invention divided out shall be considered as having been filed on the same day as the first application. So, provided that the later application is filed within 4 months after the requirement to divide becomes final or within such additional time not exceeding 4 months as may be granted, hindi graded. Okay, as may be granted. So, 4 months yung hihintayin and another 4 months for extension kapag talagang kinakailangan. Next, provided further that each divisional application shall not go beyond the disclosure in the initial application. Okay? Paano ba yung procedure for the grant of patent? Of course, meron tayong filing date requirements, meron tayong formality examinations. And pag-usapan muna natin yung filing date requirements. Sabi ito, the filing date of patent application shall be the date of receipt by the office at least the following elements. Siyempre, nandun yung express or implicit indication that a Philippine patent is sought, and then information identifying the applicant and description of the invention and one or more claims in Filipino or English. So, yung filing date requirements, kailangan ng mga sumusunod at yung magiging filing date ay yung date of receipt. Okay, formality examination. Kapag ka nag-file ka, doesn't mean na may patent ka na ha. Nag-file ka pa lang nun for approval purposes. Siyempre, i-examine muna nila yun. So, here it goes. After the patent application has been accorded the filing date and the required fees has been paid on time, the applicant shall comply with the formal requirements of the application. The patent application shall be in Filipino or English and shall contain the following formal requirements. Dapat meron kang request for a grant of a patent. Of course, you have the description of the invention. You have the drawings which are necessary for the understanding of the invention, one or more claims, and an abstract. Okay, so nakita nyo naman may mga sections naman to, no? You can see the definition of each dun sa particular article na binanggit dito. So, kapag sinabi nating request for grant of a patent, please also see section 34. Next, classification and search. An application that has complied with the formal requirement shall be classified and a search conducted to determine the prior art. So prior art shall consist of everything which has been made available to the public anywhere in the world before the filing date or the priority date of the application claiming the invention. Bakit ba kasi may classification and search na tinatawag? Kasi pag nag-apply ka, pag nag-file ka, ayan, pag nag-file ka ng application, syempre, meron kang mga documents na isasubmit. Yan, yung mga documents na isasubmit mo, hindi naman porket sinubmit mo yan ay hindi na yan bibigyan ng panahon para aralin. syempre titignan mo ng mabuti. Baka naman may nag-i-exist na prior art, meaning may nag-exist na ganyan sa iba't ibang bahagi ng mundo o maging dito, di ba? Na kahilintulad ng ginawa mo, hindi natin kasi pwedeng i-patent yan under sa'yo kung may nag-e-exist na ganyan na nauna sa'yo. That's why there is this classification and search. I-classify natin ano ba yan. Tapos isa-search natin, meron bang kahawig na yan na nauna na na-discover bago pa tong application. Ayan. So, sana na naintindihan niyo ibig sabihin ng mga conducted to determine the prior art na sinasabi. Okay, so next, the whole contents of an application for patent, utility model, or industrial design registration published in accordance with this act, filed or effective in the Philippines with a filing or priority date that is earlier than the filing or priority date of the application. Okay, so pag-usapan natin publication of patent application. So syempre, papublish natin yung application mo. Para na sa ganon, makita ng lahat, general public, general population, na may nag-apply na ganon. Nang sa ganon, kung may kontra man, at least, may inform ng lahat. Yan. So, sabi dito, the patent application shall be published in the IPO Gazette together with the search document established by or on behalf of the office, citing any document that reflect prior art, so after the expiration of 18 months from the filing date or priority date. So, ang tagal, 18 months. Ayan. So, next. Ang tagal ng proseso ng pag-apply ng patent. Ang tagal-tagal niya. Kasi, syempre, kailangan na yung proseso dumaan talaga sa tamang proseso at nang sa ganun talagang kapag nabigay sa iyo yung patent, hindi siya magiging questionable. Ayan. Pag-usapan natin approval. If the application meets the requirement, the office shall grant the patent and the patent shall take effect on the date of the publication of the grant of the patent in the IPO Gazette. Ayan. Intellectual Property Office, IPO, yung kanilang gazette daw, dun ipapublish. Ayan. So, refusal. Paano naman kapag ka ni-refuse? Siyempre, pwede ka namang mag-appeal sa director. Okay, term of patent. The term of patent shall be, this is very important, 20 years. 20 years. 20 years. 20 years. Okay. Term of patent. The term of patent shall be 20 years from the filing date of the application. Again, 20 years from the filing date. Filing date. Okay? Filing date of the application. Ang kulit ko doon, siguro naman natandaan nyo na yan. Okay, let's talk about cancellation of patents. Any interested person may, upon payment of the required fee, petition to cancel the patent or any claim thereof, or parts of the claim on any of the following grounds. That what is claimed as the invention is not new or patentable, that the patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art, or that the patent is contrary to public order or morality. So yung palang patent, kahit na mabigay na sa'yo, ibig sabihin hindi na pwedeng i-cancel. So there are grounds for cancellation of patents, and the 3 grounds are as follows. Okay? Ayan. So, rights of patentees. Rights of patentees. Ano nga ba yung karapatan ng isang tao na nakakuha ng patent? Ayan. A patent shall confer on its owner the following exclusive right. Where the subject matter of a patent is a product, to restrain, prohibit, or prevent any unauthorized person or entity from making, using, offering for sale, selling, or importing that product. Next, kapag naman ang subject matter ng patent ay process, to restrain, prevent, or prohibit any unauthorized person or entity from using the process and from manufacturing, dealing in, using, selling, or offering for sale, or importing any product obtained directly or indirectly from such process. Patent owner shall also have the right to assign or transfer by succession the patent and to conclude licensing contracts for the same. So there you go. Ito ang inyong mga karapatan. Matindi rin yung rights ng patentees kasi you can actually ask the court to restrain other people from using, okay, from using unauthorized people. Okay, so yun. Sorry, asan na ba tayo? Patent infringement. Ayan. Pirated software. Ayan, pag-usapan natin patent infringement. Ano ba ibig sabihin ng patent infringement? Diba, bilang patentee, you have the right na i-prohibit yung other unauthorized people from using your product or process. Now, there is an infringement if an authorized person make use, offer for sale, import a patented product or a product obtained directly or indirectly from a patented process. Yan. So, yun. Yun ang ating patent infringement. Ang pinaka-importante dito sa patent infringement, yung pagkakagamit, yung pagkakasale at importation ng patented product or process is without the authority of the patentee. Kapag gayon ay without the authorization of the patentee, it automatically constitutes patent infringement. Let's talk about voluntary license contract. Of course, to encourage the transfer and dissemination of technology, prevent or control practices and conditions that may in particular cases constitute an abuse of intellectual property rights having an adverse effect on competition and trade. So technology transfer arrangements shall mean contracts or agreements involving the transfer of systematic knowledge for the manufacture of a product, the application of a process or rendering of a service, including management contracts and the transfer, assignment, or licensing of all forms of intellectual property rights, including licensing of computer software, except computer software developed for mass market. Siyempre, pinatent mo invention mo for some reason. Well, mostly, ang reason niyan ay, of course, gusto mo rin na kapag nagpo-produce na, syempre, yung kita nun ay sa'yo. Lagyan natin sa perspective. Yung iyong invention, syempre, kikita ka lang din kapag mass produce mo na. So, paano mo i-mass produce yan kung hindi mo rin sasabihin yung sikreto ng paggawa, di ba? So, this calls for voluntary license contract. Para nang sa ganon, magkaroon ng transfer and dissemination of technology. Next, we have compulsory licensing. The Director of Legal Affairs may grant a license to exploit a patented invention even without the agreement of the patent owner in favor of any person who has shown his capability to exploit the invention. That is compulsory licensing. So paano to? Yung mismong Director ng Legal Affairs ng Intellectual Property Office, siya na yung mag-grant ng license para i-exploit pa yung isang patented invention even without the agreement of the patent owner. At ibibigay na to sa isang tao na may kakayanan na i-exploit pa yung invention. So let's talk about transmission of rights. So transmission of rights, inventions, and any right, title, or interest in and to patents and inventions covered thereby may be assigned or transmitted by inheritance or bequest or may be subject of a license contract. Pwede pala ito na matransmit by inheritance or bequest or by gift. Okay. So, ibibigay mo to sa ibang tao. Ayan. Parang ipapa-inherit mo pero sa ibang tao. Usually kasi yung inheritance ay terminology na ginagamit para sa pagpapamana sa mga related by blood. Okay. Next is assignment of invention. An assignment may be of the entire right, title, or interest in and to the patent and the invention covered thereby, or of an undivided share of the entire patent and invention, in which event the parties become joint owners thereof. The assignment must be in writing and notarized. So let's talk about the assignment of invention. Okay, pag sinabi nating assignment of invention, ang totoo niyan, pwede yan na i-assign to another person. Meaning to say, you are giving the right to the patent to another person. But please take note that it must be in writing and it must appear in public documents. So meaning to say, it must be notarized. So kapag ganon ang ginawa, ang magiging consequence is that the parties become joint owners of the patent. So there you go for this particular module. Please answer the exercises in this particular module. See you all in the next discussion.